Kent mother, whose son was born severely disabled, has been awarded more than £2 million in compensation from the NHS. Lisa, not her real name, brought proceedings against the East Kent Hospitals Trust after scans showing her unborn son's disabilities weren't acted on or the dangers explained to her.
Recently he's looking after 24 hours a day. You can't take your eyes off him. And if for any reason that Dad and I aren't here, we've got money to pay for help. Equipment is so expensive. We couldn't afford to pay for that on just what Dad and I have ever earned.
More than £30 million was paid out in compensation for medical errors in Kent's hospitals last year. And it's a figure that's been increasing. Joining us now is Nick Fairweather, the solicitor who was acting for Lisa, and Dr Michael Devlin from the Medical Defence Union. Good morning to you, Nick, first of all.
Good morning.
Some critics would blame the rise of no-win, no-fee lawyers for the rising number of medical negligence cases. First of all, do you think, are they rising?
Well, there's a blip at the moment, Maggie, but no, the historic trend over recent years is that so far as the NHSLA is concerned, that deals with trust cases, with most medical negligence cases, they are reaching a figure per annum, around about 10,000 sort of claims are being reached, of which maybe two-thirds of those would be processed. And when one bears in mind the NHS in all its guises treats up to 1 million people a day, you know, for all the headlines, that's not an inordinate number of itself. Obviously, what we all should be focusing on is trying to get that number down, which means there'll be fewer payouts and fewer people like Lisa left in the position that she faces currently.
And the 10,000 figure you're talking about, that's a yearly one?
Yes.
Nationally. So if you were to compare what you say, 1 million, so 365 million patients compared to 10,000, the figure is relatively small.
Yes, and I think people also need to understand, Maggie, that, you know, for a claim to succeed, the degree of fault really has to be inexcusable. It has to be a mistake that no reasonably competent doctor could make. The law recognises that competent people can make excusable mistakes and they will not ground a claim in medical negligence. It has to be sort of off-the-chart bad mistakes that are made before medical negligence law kicks in, as it were.
Are we becoming more litigious? And is that partly, I suppose, like I said about the no-win, no-fee lawyers, are we becoming more aware, maybe, of the kind of things that we could sue for?
Well, I think that must be right in the round. I mean, no-win, no-fee agreements, or conditional fee agreements, as they're properly called, they've been with us about 15 years now, and certainly it is the case that before they came into English law, were made legal in English law under the Access to Justice Act of 1999, middle-income people, ordinary people who'd suffered medical negligence could not contemplate taking on the might of the state and NHS trusts because they simply didn't have the wherewithal to do it, and it used to be said only the very rich and the very poor could afford to go to law. And what CFAs have done is open up all kinds of access to justice, including medical claims, for people who could never otherwise, from their own resources, have afforded it. But they've been with us a long time, so I think, you know, we have reached a plateau of claims in broad terms. I think there's been a blip this year, largely because as of April last year, the funding of cases changed, and I think a lot of that created a bit of a blip in terms of cases being taken forward at that point. But the historic trend over recent years is a plateauing out, and I think it reflects the fact that specialists work in this area, and it's only cases that are properly deserving upon investigation, where really inexcusable faults have taken place, that are going forward through the courts and to compensation.
Okay, let me introduce Dr Michael Devlin now from the Medical Defence Union. Good morning to you, Michael. Thank you for joining us. You heard there from a lawyer, solicitor Nick Fairweather. He was dealing with a particularly serious case, I guess. Just from your point of view, is it something that doctors, medical staff worry about a lot? This kind of litigious nature and negligence within the NHS.
Good morning, Maggie. Yes, I think it is something that doctors worry about. I'm a doctor myself, and I've been working in medical law since 1997. So it's certainly a sort of sentiment that's fed back to us on a regular basis. But where our sort of concerns are is the overall cost. It's the big picture economics of all of this. You
So the
mentioned
payouts, you mean the
figure.
payouts, the figures?
The sort of payouts, yes. What's its cost to society? The figure for Kent was mentioned, and indeed, if you look at the whole of England, the NHS Litigation Authority, which funds the NHS hospitals bill, believes that for all those cases that it has paid out in the sort of last year, but it will also pay out in future years, for instance, that have already occurred. That figure is just short of £26 billion, so it's a very, very large number indeed.
But I suppose, Nick, can you put a figure on, without talking specifically about Lisa, her case, can you put a figure on, people suffering from negligence of this type? Because can you put a figure on the physical needs of that person, but also the stress that it would have caused?
I think you can put a figure on that, and some of the ideas that we're putting forward is to reform the way that damages are calculated so that it's fair both to patients and also to society. And one of the principles that we've been talking about is the fact that because of a sort of 1948 Act, damages are calculated on the basis that all future care, both health and social, will be provided in the private sector. We think that particular section of the 1948 Act should be repealed so that NHS and local authorities can put together packages of care. And the benefit of that would be that money that would otherwise leave the NHS or local authorities could then be fed back in. So it would be inward investment coming back in. And the side effects of that would be that the investment could increase services for all patients rather than just the patients who've been directly affected. So,
Nick, I'll just go back to Nick Fairweather for a moment. Nick, does it matter to you, or do you think it would matter to anybody that you work on behalf of, where the money comes from?
Well, it's the level of provision, Maggie, that's important. And this suggestion from the MDU that we cap future care just doesn't make sense, unfortunately. I mean, let's go back to Lisa's case. Her son needs 24/7 care. Okay, he needs someone constantly looking and watching over him. And the largest element of the just over £2 million award that the family have received is for that future care. Now, that care is not paid at some inordinate rate. The carers that have to come in and provide that care are costed about £11 an hour. Now, that's not an inordinate rate for the high level of care that's necessary there. And state provision just isn't adequate. If you look at what direct payments would pay, this family has a few hours a week from direct payments,
okay.
And it just doesn't fill the hole. And the reality is, I mean, the MDU is a doctors' trade union, and effectively through indemnity, it's an insurance company. But already the state, particularly the NHS, subsidises insurance companies hugely. If someone is left with lifelong NHS needs paid by the taxpayer because a drunk driver has run them over and left them paraplegic, it's a taxpayer that's picking up the tab. So the idea that process should be taken a whole step forward, it doesn't seem fair to anyone, and certainly it won't provide adequate or fair compensation for victims like Lisa.
We must leave it there now, Nick, but thank you for joining us. Nick Fairweather, the solicitor who was acting for Lisa, and Dr. Michael Devlin there from the Medical Defence Unit.